Morning, I'm Brian Murchison. I'm a member of the law faculty. It's my pleasure this morning to introduce the members of our first panel. Before I do, let me just recognize that we have a number of very welcome visitors here today, and I'm thinking of Tom and Shelley Milheiser in the front row who helped make this beautiful room possible for the law school. It remains the heart and soul of this building, and we welcome you all here today. Also, Charlie and Lee Rowe are here with us today. Charlie's a former newspaperman, editor, publisher in Virginia. He is a great friend of Washington and Lee and has supported our programs in law and journalism for a long time. So it's great to have Charlie and Lee with us as well. Now let me introduce the members of the panel. Kathleen M. Sullivan is one of the country's preeminent scholars and teachers of constitutional law, was named by the National Law Journal as one of the 100 most influential lawyers in America. She's written leading case books on constitutional law and on the First Amendment, and is an outstanding litigator who has argued before numerous courts of appeals and the U.S. Supreme Court. She joined the Stanford law faculty in 1993 after teaching at Harvard Law School for a number of years. From 1999 to 2004, Professor Sullivan served as the 11th Dean of Stanford Law School and the first woman dean of any school at Stanford. Her record as a dean is extraordinary. She made numerous faculty appointments, established the clinical faculty there, launched academic centers, started the LLM program, raised many millions of dollars for the school. She has a BA degree from Cornell, was a Marshall Scholar at Oxford. She received her JD from Harvard. She is an elected fellow of the American Academy of Arts and Sciences and of the American Philosophical Society. She's known to students at Washington and Lee as the author of a brief in the U.S. Supreme Court that we study in the first year. So I really welcome you to Washington and Lee today. Our second panelist is Rod Smolla, the new dean of Washington and Lee Law School, himself an outstanding First Amendment scholar. His book, entitled Free Speech in an Open Society, won the William O. Douglas Award in 1992 as the year's best monograph on freedom of expression. His book, Suing the Press, Libel, the Media, and Power, won the ABA Silver Gavel Award Certificate of Merit in 1986. He's the author of 3 treatises, Smolla and Nimmer on freedom of speech, federal civil rights acts, and the law of defamation. He's also the author of a case book on the First Amendment and co-author of a case book on constitutional law. He's a well-known advocate in cases involving civil rights and mass media. He's argued cases at every level, including the Supreme Court of the United States. He's a graduate of Yale College and Duke Law School. He was formerly dean of the law school at the University of Richmond, and before that he was director of the Bill of Rights Institute at William & Mary. And in a very short period of time, he's become an indispensable member of the W&L law family. So it's great to have him on this panel. And to his right is James B. Comey, currently General Counsel and Senior Vice President of Lockheed Martin. He was Deputy Attorney General of the United States, serving in that position from December 2003 through August 2005. He was then the second highest ranking official in the Justice Department and ran the day-to-day operations of the department. In that position, he appointed Patrick Fitzgerald, the U.S. Attorney in Chicago, as special counsel to head the Valerie Plame leak grand jury investigation. Mr. Comey served as U.S. Attorney for the Southern District of New York for 2 years before being appointed Deputy Attorney General. As U.S. Attorney, he oversaw numerous terrorism cases. He supervised prosecutions of executives of WorldCom, Adelphia, other entities in fraud and securities-related charges. He created a specialized unit to prosecute international drug cartels. From 1996 to 2001, he was managing assistant U.S. attorney in charge of the Richmond Division of the U.S. Attorney's Office for the Eastern District of Virginia. He's a graduate of William & Mary, holds a law degree from the University of Chicago. He was law clerk for U.S. District Court Judge John M. Walker, Jr. While in Richmond, he also served as an adjunct professor at the University of Richmond Law School. We will proceed as follows. Dean Smolla will get things started by addressing the case of Brandsburg versus Hayes, that 1972 Supreme Court decision on reporters' privilege, in which Justice Powell concurred with the majority, yet wrote what has been called the enigmatic concurrence. After Dean Smolla reflects on Brandsburg, Dean Sullivan will consider the aftermath of Brandsburg and its forward march to present day, with reference to current arguments and cases in which journalists' privilege is a central issue. Then Mr. Comey will round things off with his reflections from the perspective of a former federal prosecutor in investigations dealing with national security and the availability or lack thereof of evidence from journalists. So Dean Smolla, will you come on up?
Thank you, Brian, and good morning again, everyone. Not far from where we are at this moment, in a climate-controlled room in the library of the law school here, are the papers of Justice Powell. And I brought with me for you to see the files in two of his cases that dealt with the intersection of law and journalism. The first is his file in the Brandsburg case. Here it is. And the second is his file in another very famous case involving the First Amendment, a case called Gertz versus Robert Welch, involving defamation law and the levels of fault that apply when either public figures or private figures sue the press or a publisher for libel. The Gertz case is another of Justice Powell's masterpieces, and here's the file in that case. Now, I thought it would be interesting to compare the two for a number of reasons. First, for what they reveal about the character and the judicial deportment and temperament and thought processes of Justice Powell. And second, for what they reveal about the relationship between journalists and their sources. In comparing the two cases, it's first interesting to reflect on their similarities. As several people have mentioned, including President Ruscio, Justice Powell was often the person in the middle. In that sense, he was a mediator between the more liberal wing and the more conservative wing of the court at his time, and he occupied a position not unlike that which would later be occupied by his friend, Justice Sandra Day O'Connor, and occupied today by Justice Anthony Kennedy. But as President Ruscio suggested, there's more to it than just being the person in the middle. Because what I think you will hear throughout the morning is that Justice Powell had a penchant for genuinely appreciating and understanding and internalizing the validity of conflicting constitutional values and conflicting constitutional arguments. And so he wasn't simply a weak compromiser, but he was more a creative resolver who sought to look for resolutions that would balance the interests at stake. You see that in these two opinions, and you see it throughout his jurisprudence. Probably most famously, not with regard to the First Amendment, but with regard to equality, to race and gender discrimination. Perhaps his most famous opinion, of course, is his opinion in the Balco case, in which he at once rejected the claim of the University of California at Davis that it could employ a quota system in order to achieve racial diversity and ethnic diversity, but at the same time approved of the notions of universities in the pursuit of diversity in higher education engaging in race-conscious measures. You see it in his jurisprudence in gender equality in a very famous case called Frontiero versus Richardson, in which the issue was discrimination between male and female members of the armed services. There were a group of justices who wanted to equate gender discrimination with race discrimination and apply a very high level of constitutional scrutiny to gender discrimination, essentially identical to the way in which we treat race. And there were a group of justices who did not want to do that, and Justice Powell ended up occupying a middle ground, arguing for an intermediate level of scrutiny. And that remains today the law of the land. Itself also connected here to Lexington, Virginia, because the test announced in the Frontiero case would be the test subsequently applied by the Supreme Court of the United States in United States versus Virginia, in which our neighboring university of VMI was forced by our federal courts to co-educate. Now, the other characteristic that is very powerful in Justice Powell's jurisprudence throughout his cases is that his rulings often seem to invite subsequent conversation, subsequent democratic experimentation by the states and by the Congress, and subsequent judicial elaboration. This was a common characteristic. And so, if you think of the Bakke case, there would be decades and decades of ferment over the role of race-conscious measures to achieve diversity in higher education. Federal courts would split on the meaning of Bakke and on the role of Justice Powell's opinion. Ultimately, the Supreme Court of the United States and the University of Michigan cases would follow the roadmap that he said in a decision that approved of the race-conscious measures at the law school, but not at the undergraduate school, and Justice O'Connor would embrace the values of Justice Powell there. But the democratic conversation would continue, and states such as California and Michigan and Texas would ultimately, through political action, reject the concept of affirmative action that the Supreme Court and Justice Powell seemed to approve. In the two cases that I want to talk to us a bit about, you see that. In the Gertz case, Justice Powell said that the two conflicting constitutional values are, first, the obvious value in a robust press reporting on national affairs, and second, the countervailing social value in the protection of individual reputation and human dignity. And the compromise that he struck was a rule that provided a very high level of First Amendment protection when the person suing for libel was a public figure or a public official, but a lower level of protection when the person suing for libel was a private figure. In the Gertz case, however, Justice Powell said that this was simply the First Amendment floor, and that states were free, if they chose, to elaborate on that and to add protections beyond that. And a number of states, a handful of states, including New York, a very important state for media purposes, did adopt higher standards for private figure cases. If those are some of the similarities between Brandsburg and Gertz, what are the differences? I'll hold the two opinions up again for you to see. Gertz is a much thicker file than Brandsburg. Gertz is an elaborate, well-thought-out, comprehensive solution to the problem of public figures and private figures and the reconciliation of the value of reputation and the First Amendment. Gertz is a finished thought. It reads almost like the restatement of torts. It is an elaborate matrix of rules, not only dealing with the public figure-private figure dichotomy, but many other elements of damages and fault in defamation law and its intersection with the First Amendment. It is a complete body of work, it is a finished product, and it has proved remarkably stable. Although there have been elaborations on Gertz and tinkering with it on the margins, it has been a guideline that has existed essentially without controversy for nearly 3 decades, and hundreds of courts have decided cases under Gertz and interpreted it, and it is not in play in current constitutional law or, for the most part, in our public discourse. It is a settled matter. Brandsburg, on the other hand, is an incomplete thought. It's only a few pages long in his notes, and his opinion for the court is but a few paragraphs long. And I don't think that Justice Powell reached real resolution in the Brandsburg case. I don't think he was able, in his own mind, to complete the project in the way that he did in Gertz. And so the interesting question is, why might that be? I'm going to suggest to you that Justice Powell, as revealed in his notes on the case, felt very, very acutely the power of the conflicting forces that are at large when we deal with the question of whether a journalist should be able to keep his or her source confidential from a judicial inquiry, either at the grand jury level or in a trial. And in his own mind, I do not believe that those conflicts were reconciled. And that's one of the reasons that lower courts have split over the meaning of Brandsburg, and that's one of the reasons that it continues to be hotly contested in our political and cultural debates. So what are the conflicts? There really are two. On the side of journalists, there is, of course, the notion that the protection of the confidentiality of one's source goes to the heart of the news-gathering process, and we have a more robust search for truth on the part of journalists if they are able to grant to a source a promise of confidentiality that is judicially enforceable. What are on the opposite side of the argument in Brandsburg? Two constitutional values. The first constitutional value is nothing less than our commitment to the rule of law. There's first the surface notion that is part of the heart of all of our law, that no person is above the law. When a journalist says, although most people in society would be forced to swear on an oath to tell the truth, the whole truth, and nothing but the truth, and reveal the evidence that they know, a journalist, when a journalist asserts the privilege, is claiming, in a sense, to be above that, to be exempt from that. That is, of course, always the case when, in a trial or in any judicial proceeding, a person invokes a privilege and claims as a matter of right that they do not have to give the evidence that other citizens would be required to give. Indeed, it's helpful to think about the connection between executive privilege and the journalist's privilege. On a certain level, they are both the same claim. And in United States versus Nixon, the famous executive privilege case, you may remember that the pervasive theme in the opinion for the court in that case is the notion that it is sacred in our country that no person is above the law, not even the President of the United States. And even the President of the United States may be required to answer to judicial process, and although there should be an executive privilege, that privilege can be overcome by a court that decides that the compelling need for the judicial branch to ferret out the truth trumps the value of that privilege as an expression of the importance of the executive and the importance of the executive having candid conversations with his or her advisors. In the journalist's case, much the same dynamic is arguably at work. Yet in our law, we often do grant privileges. We often do say that because of the nature of a relationship or because of larger social values that are at stake, we will not require that someone give evidence in a court of law as they would otherwise be required to do. Usually, that involves a combination of a special relationship that the speakers had with one another that society decides is especially worthy of encouraging. And so there are privileges for the husband and the wife in marriage. There are privileges for the attorney and the client. There are privileges for the priest and the penitent, for the psychiatrist and the patient. There is a privilege for the President of the United States and his or her close, intimate advisors, in part because we want to strengthen that bond and strengthen that relationship. Parallel to that is the notion that as part of that relationship, we want to encourage candor. We want those people to be able to talk fluidly and exchange information between them, and we don't want the fear that what they say to one another, or even their identity at times, may later be brought into public scrutiny. Now, in the case of a journalist, there isn't the special bond quality. That is to say, the relationship between a journalist and a source doesn't have that fiduciary quality, that pre-existing relationship quality that you see in some of the other instances. But it does have going for it the very powerful notion that we grant the privilege because it is very important for a larger public to hear the information that the journalist wishes to report on, and to encourage the flow of information from the source to the journalist, we allow for the privilege. So in the last few minutes, I want to cross-examine that claim a little more deeply and test it against two things. First, whether it is a strong empirical case, whether in our experience we really believe that the judicial recognition of the privilege is essential to encouraging robust news gathering. And secondly, the dilemma that we are faced with if we grant the privilege because it invites us apparently to discriminate among different kinds of speakers and different kinds of news gatherers, something that is particularly acute today in the modern age of the internet and blogging. Let's first just think for a few moments about the empirical case. Is it true that promises of confidentiality to sources encourage and facilitate news gathering and the free flow of information in our society? It seems to me self-evidently obvious the answer must be yes. Of course that is the case. Every day throughout the country, hundreds of stories appear in newspapers and broadcast media on the internet in which a pivotal piece of the story is based on information from an unnamed source or a confidential source. If you watch CNN for 3 or 4 hours this evening or the ABC News broadcast, you will likely today see a story or 2 or 3 in which an unnamed source is pivotal with regard to the story. All right? But that's not the entire question, because the question is not whether it is important for journalists to be able to promise confidentiality. The question is whether it's important for a court to later honor that when it is tested in a judicial proceeding. And this, here I think the case is more ambivalent. First of all, recognize that in only a minuscule percentage of cases will the promise of confidentiality ever even reach any judicial forum. Today there may be hundreds of stories in print in which there are confidential sources. The odds are that in none of them will there ever be a judicial proceeding in which the journalist will be asked to testify. In fact, the probability is that out of the thousands and thousands and thousands of promises of confidentiality in any given year, a handful ever result in a journalist being brought before a grand jury or brought before any sort of investigation in which the journalist is asked to reveal the source. And so that forces us to ask, what is it that's being promised when the journalist says, yes, this is on background, yes, I promise that I will not reveal your name? Is it that the journalist is saying, I won't use your name in the story? Period. The journalist might not be saying, but, and if later asked by a prosecutor to reveal your name, or by a judge to reveal your name, I will invoke a privilege and try to resist revealing your name. But is it also true that the journalist is saying, I will go to jail for you? I will engage in civil disobedience. I will place myself, if you will, beyond the law or above the law. And even when our judicial processes say that the privilege doesn't exist or has been overcome, I will hold the line and refuse to divulge your name. It seems to me a bit unclear as to whether that is actually part of the promise. Is the promise, I will go to jail, or is the promise, I will do all that I can within our legal structure to avoid revealing your name? But if there comes a point at which the ordinary processes of law say the privilege ought to give way to the need for every person's evidence, at that point, I will not be a journalist, I will be a citizen, and I will obey the rule of law, and I will give up your name. It's unclear, but you can see that if it's the second of those sorts of promises, one could make the argument that, in fact, nothing will be lost, nothing much will be lost if there is no judicial recognition of a journalist's privilege, Because overwhelmingly, journalists will grant promises of confidentiality. Overwhelmingly, it'll never be tested. And in the cases in which it is tested, it doesn't matter, in a sense, whether the privilege is judicially honored or not, because that wasn't the promise that the source and the journalists were thinking of at the time of the original transaction. The second problem, which I've already alluded to, is that if you grant journalists a privilege, you must decide what a journalist is. This is a headache in terms of First Amendment theory, because for the most part, we have resisted in First Amendment law picking and choosing among speakers. Indeed, in the Brandsburg case, one of the themes was whether the press clause would have independent meaning that supplied a special protection for the institutional press different from the protections of the speech clause, which provide protection to ordinary citizens. And for the most part, our Supreme Court has refused to pick and choose. It has refused to breathe special meaning into the press clause, and it generally says that it violates the First Amendment to pick and choose among speakers. And so, if one of you in the room, not a member of the institutional press, were to interview someone for some sort of activity that you wish to engage in, some expressive activity that you wish to engage in, and if one of our visitors from C-SPAN today, a member of the institutional press, of course, were to make the same promise to the same person, if there is a reporter's privilege, arguably, the members of the official press would get the benefit of that privilege, but the amateurs would not. All right? And this offends our sense of sort of an egalitarian First Amendment. Obviously, this is made far more intense given the emergence of the blogosphere and the role of amateur journalism as an enormously important engine in our public discourse today, in which we have largely broken down the concept that there even is such a thing as a world of professional journalism, clearly distinct from the other forms of sort of public participation journalism with which we all engage. Last point, I'll close with this. I said to you that Justice Powell's opinions often invited subsequent democratic discourse. And in this case, with regard to reporters' privilege, what has happened in that subsequent discourse is striking. Although the Supreme Court of the United States appeared to reject the existence of a First Amendment privilege in Brandsburg, and I will tell you, if you come up afterwards and look through these notes, you will see in Justice Powell's handwriting numerous times underscored no First Amendment privilege. So it's difficult looking at his notes to interpret the case as if it, in fact, was intended to create a privilege. Even though the Supreme Court rejected that view, as Kathleen, I'm sure, will tell us, many lower courts relying on the Powell opinion said, either as a matter of First Amendment law or as a matter of federal common law, a privilege did exist in the federal system. That was particularly true in the early years following Brandsburg. The tide has turned, and there have been many influential lower court opinions. Of course, the most important recently, the Judith Miller litigation, in which the claim that Brandsburg creates a privilege has been rejected. Even so, the democratic dialogue and the judicial evolution dialogue has continued. And today, 49 states and the District of Columbia recognize some form of reporter's privilege. They have either enacted legislation creating a shield law, usually a qualified privilege, in some states an absolute privilege for confidential information, or as a matter of state common law or state constitutional law, some form of privilege has been recognized. Now that is an interesting exercise in reverse federalism. You know that Justice Louis Brandeis said that the states should be laboratories for experiment. And to the extent that the states have been laboratories for experiment on this issue, it would appear that the results are in. There's been a kind of collective democratic plebiscite, and there is an overwhelming consensus, it appears, that it is valuable to society to favor the truth-seeking engine of the press and the free flow of information over the truth-seeking information of our courts and the pursuit of the rule of law, at least by balancing the two, at least by giving journalists a threshold right to claim the confidentiality which a court may or may not later override. There is now, of course, a great debate going on in Congress over whether there should be a federal shield law. Because if the First Amendment cannot be counted on as the source of such a law as a matter of constitutional law, obviously Congress could do what the states have done and create some form of shield law. My own view is that such a law should be adopted, and that the balance that has been struck by the states is the appropriate balance. I'm sure our panelists in this panel and in the next panel will elaborate on some of the conflicting policy issues, but a very quick roadmap as to what I think ought to emerge, though I doubt any of this will emerge. I think there ought to be a shield law, but I don't think it ought to be absolute. Just as executive privilege is not absolute, I think that the journalist's privilege should not be absolute, and a court should be permitted to weigh the conflicting values. The privilege should apply broadly, beyond the institutional press, to anyone who is engaged in the functional equivalent of news gathering and dissemination to a mass audience. And so a blogger in his or her room using his or her computer to ferret out information is entitled to the privilege every bit as much as a reporter for the New York Times if they are engaged in the functional equivalent of news gathering. As many courts have recognized, the privilege ought not be a have your cake and eat it too matter, and this means that at least in civil litigation, in, for example, defamation cases, if a journalist relies on a source for a story, and if the object of the story sues for defamation, and if the journalist says, I am innocent of actual malice, I am innocent of fault here because I had a source, the plaintiff may then ask, well, who was your source? How do we know there was a source? How do we know you didn't make the source up? The journalist may be able to invoke the privilege, and indeed a court may honor the privilege, but then the journalist ought not be entitled to rely on the existence of the source to prove the absence of malice. And there are a number of state court decisions, importantly in New York, that say that that is the trade-off that is appropriate. If you wish to retain the confidentiality of your source, you can't have your cake and eat it too and say, oh, I've got a source, therefore I'm not guilty of actual malice, that you've got to make that decision. Finally, the question that has tended to be the issue on which our society has hung up, particularly since 9/11, which Lewis Powell alluded to, is the question of whether there should be a per se national security carve-out for the assertion of the source. Actually, thinking back to United States versus Nixon, you may remember there are suggestions in the case that the executive privilege, if invoked by the president in a national security matter, might be absolute, might not be something that could be overridden by a court. It's never been resolved again by the Supreme Court of the United States. But there are many in Congress who would say that the reporter's privilege should always give way if what is being reported on touches on matters of national security. I think this is profoundly wrong and exactly the opposite societal value. Because if anything has been proven, including by the brave actions of some of the people on the panel today that you will hear from, it is that when matters of national security are at stake, it is enormously important, it is particularly important that there be a robust fourth estate engaged in news gathering as a check and balance on the executive branch and on the political branches. And so there ought not be a blanket exception for national security. There ought instead be a case-by-case balancing of the competing interests. Thanks.
Good morning, ladies and gentlemen. President Ruscio, Dean Smolla, members of the Powell family, and Washington and Lee community, it is a great honor to be part of this symposium in honor of the great Justice Lewis Powell. And I'd like to tell a story in three parts, picking up where Dean Smolla left off. Justice Powell's First Amendment. Let's begin with the first part, Justice Powell's First Amendment, as illustrated by his oracular concurrence in Brandsburg versus Hayes. Second, the era when, despite its brevity, as Dean Smolla already suggested, that opinion ruled in the lower courts over the words of the plurality opinion. And the third act is the retrenchment from Justice Powell's First Amendment in the recent era. And I'm going to ask what has changed, and then I'm going to ask the question, what would Justice Powell say if we could parachute him into the current environment and ask him to analyze Reporter's Shield against the backdrop of current events? Now, to begin with, Justice Powell's First Amendment as exemplified by his concurrence in Brandsburg versus Hayes, I want to suggest to you that it had three features of his jurisprudence. Dean Smolla has already alluded to this, but first is a solicitude for the original Bill of Rights, a solicitude for the First Amendment that's exemplified in his words when he says the court does not hold. He tries to say the plurality, although it denies a privilege for reporters who had reported on hashish making and bomb plots discussed by a Black Panther meeting. He said, although the privilege doesn't apply to the reporters who reported on those stories and then refused to testify before a grand jury, even if they could keep the identity of their sources confidential, he says, I'm going to provide the fifth vote to hold that they do not get to have an absolute privilege against grand jury testimony. I'm going to agree with Justice White and the four justices in the plurality on that point. But, and here's his solicitude for the First Amendment, his concurrence opens, the court does not hold that newsmen subpoenaed to testify before a grand jury are without constitutional rights with respect to the gathering of news or in safeguarding their sources. The solicitude repeatedly shown by this court for First Amendment freedoms should be sufficient assurance against any such effort. I'm not saying this in the mellifluous Virginian with which he would have said it, but I hope you'll understand it anyway. Second feature besides solicitude for the First Amendment was balancing, as Dean Smolla has already suggested. The approach, the methodological approach of balancing. He says the asserted claim to privilege should be judged on its facts by the striking of a proper balance between freedom of the press and the obligation of all citizens to give relevant testimony with respect to criminal conduct. That kind of balancing was absolutely typical of his decisions in other areas, whether it was in the Bakke concurrence, another 5-4 concurrence that determined a generation of institutional practices, in which he said quotas on the basis of race are not a sufficient safeguard of the guarantee of equal protection, but taking race into account as a factor to remedy past sins of discrimination or to provide diversity in the people we graduate from the nation's colleges, that's okay, that kind of balancing of interests. And third, it exemplifies his case-by-case approach. He said the balance of these vital constitutional and societal interests on a case-by-case basis accords with the tried and traditional way of adjudicating such questions. So it would matter to Justice Powell whether on the facts the government was harassing the press. You might remember that Governor Huey Long once imposed a special tax on a newspaper over a certain size, and when asked why he'd imposed it, he imposed it on a newspaper that had been somewhat critical of his governing practices. And he said, oh, it's a tax on lying. So we have a longstanding First Amendment tradition that says that when government actually singles out the press for special punishment or persecution, that's not going to be allowed. So Justice Powell cared about the facts. Was the government acting in good faith? He cared about relevance. He said government shouldn't be allowed to go after a grand jury subpoena that has only remote and tenuous relationship to the subject of the investigation. And he spoke about the legitimate needs of law enforcement. All right, so three features: a solicitude for the First Amendment, a balancing approach that acknowledged governmental need, but wanted to look at that need case by case. And that resonates absolutely with his other opinions, Bakke, or the opinion in Plyler versus Doe, on which you'll hear an eloquent lecture by Linda Greenhouse this coming Wednesday, when he said that the right to education is so important that you can't exclude undocumented alien children who were here by no fault of their own absolutely from the schools, even if there was no right to an equal education in terms of redistributing finances. So case by case. Now, I've speculated why did Justice Powell have that particular combination of attitudes? Where did his solicitude for the press come from? What drove him to go to all the trouble, even if the file is slim, to file that special concurrence in Brandsburg versus Hayes? And I reflected on his life, the magnificent life and the law that's reflected in his work as a corporate lawyer, as chairman for a decade of the Richmond School Board, as president of the American Bar Association after tenure on local bar associations. And I thought, well, he must have known a great deal about the press in those capacities, of its power and its foibles. He must have known how to deal with the press for good and the dangers of the press for interference with the work he was trying to do on behalf of his clients, on behalf of the school board, on behalf of the bar. And I speculated that Justice Powell was someone who believed in a kind of tacit backdrop to the First Amendment. You know, we all have tacit assumptions about constitutional rights. They're so given that we don't even think about them. When we have a right to be secure in our papers, houses, and effects, we need warrants and knock and announce before the police come through our door. Well, we assume we have a reasonable expectation of privacy because we tacitly assume we don't live in glass houses, that a house is a place that's shielded from the view of the world. Well, similarly, I think behind the First Amendment, I think Justice Powell may have had a tacit assumption that the relevant elites here would behave responsibly with institutional self-restraint. On the one hand, the press would exercise self-restraint so that when it really needed to go underground into a Black Panther meeting, a hashish factory, a Klan meeting in the woods, and get a confidential source to report a story, then and only then would it rely on confidential sources, only when it could get the information only by secrecy. At the same time, I imagine that Justice Powell, having worked with many prosecutors on the other side of corporate issues in his time, believed in the self-restraint of the federal prosecutors and state prosecutors who might subpoena those reporters. A view that they wouldn't go after the reporters unless they'd exhausted every other lead, given every other investigative opportunity, come to the press last. And you see that Justice Powell is thinking this way when he writes in his Brandsburg concurrence that you should not read this opinion to allow the government to annex the press as an investigative arm of the government. So I imagine him trusting in the self-restraint of well-meaning elites, prosecutors on the one hand, the institutional press on the other hand. And this trust in the leadership of our societal institutions is evident elsewhere in his opinions. When he speaks of the self-restraint that college admissions officers will exercise under his opinion in Bakke, he's imagining that there will be internal self-restraint, self-governing rules of conduct that can be trusted to create, in this context, a kind of gentleman's agreement. Government will only come after you for your sources if they really need it. You will only rely on confidential sources if you really need them. I ventured to suggest this interpretation to Lewis Powell III and asked whether it resonated at all with his sense of his father, and he said I wasn't completely out of line, that this trust in institutional self-restraint was perhaps a feature of his father's view of the world based on his participation in those important leadership roles. So if we take Justice Powell's First Amendment, we have to close that chapter by saying he believed that there would be a self-regulating system operating through mutual self-restraint. Now let's go to Chapter 2, the period from 1972 until our recent era, when Justice Powell's concurrence in Brandsburg versus Hayes really did become the law of the land, even though it was a concurrence. And technically, it was needed to decide the case. There were 4 dissenters who vigorously thought the privilege should have prevented the subpoena from being executed against the reporters in that case. So in order to decide the case in favor of the privilege, it's a canon of construction of a Supreme Court divided opinion that the vote needed to create the narrowest ruling is the one that's decisive, and here that was Justice Powell's. And for several decades, his concurrence was taken as the law. There were 3 important outcomes of that concurrence being viewed as the law. The first, Dean Smolla has already alluded to, it had a great effect in state lawmaking. The states all followed Justice Powell's lead, saying there's a qualified privilege, not an absolute privilege, but a qualified privilege for the press to shield its confidential sources. 32 states by statute and 17 states by constitutional interpretation or state evidentiary privilege making, common law interpretation, now have some form of qualified privilege. And that effectively mooted a lot of controversies when state prosecutors might have sought to go after their reporters, as the state prisons, the state jails were not full of the staffs of the local dailies because of that influence. But even in federal court, Justice Powell's concurrence had 2 important consequences. First, it became quite common for the courts to recognize a qualified privilege for reporters to shield their confidential sources in civil litigation, where there wasn't a defendant's Sixth Amendment rights at stake, where he really needed to know that information to confront the witnesses against him. And in civil litigation, it became common to say the reporter can shield his sources unless the government can overcome the high hurdle of showing that it really needs the information and it has no alternative source besides the reporter. 1981 decision by the D.C. Circuit started that trend, and many other circuits agreed. The Ninth Circuit found that privilege in a defamation case where said the plaintiff has not exhausted relevant alternatives. So first, there was a qualified privilege in civil litigation. And second, in the federal courts, there was even a recognition in many circuits of a qualified privilege in criminal cases when the government sought to get the reporter to turn over his sources. The Third Circuit, in a case called Cuthbertson in 1980, in a fraud and conspiracy case involving some outtakes from 60 Minutes that the government wanted to get its hands on, said, no, we're going to quash the subpoena. The government hasn't shown it really needs those outtakes. Same thing in an 11th Circuit case in 1986 called Caporale, a case involving jury tampering, or a case in the Western District of Pennsylvania in 1991, for example, quashed a grand jury subpoena which was seeking leaked FBI reports in connection with a corruption investigation. And the Western District of Pennsylvania judge said, I read Justice Powell in Brandsburg to say that the government needs to show it has exhausted its alternatives. If these leaks were coming out of the government, we think the government has a good opportunity to exhaust other means of investigation besides subpoenaing the reporters. So just to summarize, Justice Powell's Brandsburg concurrence rules the nation three ways from about 1972 into our current era: through influencing the states to adopt and increasingly adopt a qualified privilege as a matter of state law, in influencing federal circuit courts to create a qualified privilege in civil litigation, enabling reporters to keep their confidential sources unless a plaintiff shows it really, really needs that information and can't get it elsewhere, and even in criminal investigations, shielding reporters against grand jury subpoenas, telling the government it has to clear a high hurdle of assuring the court that it can't get the information elsewhere. Now let's turn to Chapter 3 of the story, our current era. As Dean Smolla suggested, the tide has turned. Increasingly, we see that it's Justice White's plurality opinion saying no First Amendment privilege for reporters to shield their confidential sources that gets cited as the law of Brandsburg. And Justice Powell's concurrence gets increasingly ignored in current cases. We see that, for example, reporters in civil proceedings have been held in contempt for failing to turn over their information. This in the Wenho Lee case, the case of the Los Alamos scientist accused of having passed over intelligence secrets to foreign powers. He brought a Privacy Act challenge saying, I was wronged, I want information from the government to clear my name. And in the course of that Privacy Act challenge, he sought to subpoena to obtain discovery, civil discovery, not of information from reporters who had covered the story. And the D.C. Circuit, in an important 2005 decision, said, I'm sorry, Brandsburg, Justice Powell, that was a concurrence. The holding in Brandsburg was no First Amendment privilege for reporters to shield their sources, and in this case, it upheld the contempt against these journalists for violating a civil discovery order, reading Brandsburg quite narrowly. Also, in recent criminal cases, especially in the leak context, as Dean Smolla has already alluded to, the court has now, the lower courts have tended to read Brandsburg quite narrowly and to say there's no privilege. There's almost an absolute rule, according to some of the lower courts, that if there's a grand jury subpoena, all bets are off. Reporter loses. Turn over those sources. There's no privilege whatsoever. There's almost a rule in favor of the government rather than a balance. The Judith Miller case in the D.C. Circuit in 2006, no special press privilege in a grand jury subpoena case. The McKevitt case out of the Seventh Circuit, in which influential Judge Richard Posner said, I've read these cases in which people seem to be relying on this opinion by Justice Powell. Did anybody notice that it was a concurrence in a decision holding that there's no privilege? And in this case, he held that a foreign criminal defendant could obtain information from a reporter about secret sources in a case that was relevant to the foreign criminal prosecution. This case was overdetermined because the confidential sources had waived the privilege, and to Posner, who thought that it's the source who owns the privilege, not the reporter, that was the end of the matter. But if you don't want to focus on McKevitt, take two more cases recently, a First Circuit decision in 2004 in Ray Special Proceedings, a case involving corruption by city officials and an ongoing investigation, criminal investigation. There, the First Circuit said the privilege is rejected so long as the information is not readily available to the government through a less sensitive source than the reporter. The presumption is shifted. Under Justice Powell's First Amendment, there was kind of a presumption in favor of the press, and the balance would tip only if the government showed it couldn't get the information by other means. Now the presumption is kind of in favor of the government. If it was too inconvenient to find another source, then we would exercise the contempt power of the court over the reporter to cough up the sources. Or New York Times against Gonzalez, Second Circuit in 2006, saying there's a limited privilege. Maybe there's a limited privilege in a grand jury subpoena case, but it's easily overcome by the government. All right. So those are just a few examples. Judith Miller, Wenho Lee, McKevitt, In Re Special Proceedings, New York Times versus Gonzalez, in which suddenly it's Justice White's plurality opinion and not Justice Powell's concurrence that dominates the reasoning, and the privilege claims are rejected again and again. The presumption seems to be in favor of the government, especially in grand jury subpoena cases. Now, what I want to do next is say what changed between those two eras. Justice Powell's First Amendment that dominated for 3 decades, and the switch now toward a deference to governmental requests and plaintiffs' requests for information from reporters about their confidential sources. And I want to suggest to you that there are 3 changes in the backdrop, in the social, institutional context in which these cases arise. First is one that Dean Smolla already alluded to. First is a change in the nature of the press. Who is the press? It's no longer the Columbia School of Journalism graduate following the code of institutional self-restraint, 2 sources, corroboration, fact-checking, getting your info. It's people in their pajamas blogging in over coffee. So the press is no longer a confined institution with a hierarchy and a set of institutional codes and self-regulation that can be relied on, as I think Justice Powell's First Amendment did, to make selective use of confidential sources, the rise of the blogosphere. There's a change even within the institutional press, in which there's been an increased reliance on confidential sources. After the success of Bernstein and Woodward in unmasking the Watergate scandal through the use of the confidential source in the parking garage, Deep Throat, whose identity we finally learned shortly before his recent death, now every reporter wanted to have a deep throat. Now every story was done with confidential sources. The kind of casual and excessive use of confidential sources made it somewhat pedestrian rather than the kind of thing the reporter only did when he had to infiltrate the secret meeting. And of course, there were some prominent cases where the confidential sources did turn out to have been fabricated, and then that was like the 13th chime of the clock. It made the public wonder whether other confidential sources had been fabricated too. And it may be that this kind of promiscuous use of confidential sources was encouraged by the rise of the state shield laws that encourage reporters to be bolder as against state prosecutors in knowing that they wouldn't get caught. So first is the change in the nature of the press. Second is the change in the nature of the government's approach to self-restraint. Now, I know you're going to hear later from our very distinguished prosecutors who are with us today, for whom I have the greatest respect, and I know you're going to hear from them about the Department of Justice guidelines and how important that those guidelines in place since the 70s and now codified in 28 CFR. Justice Department has a set of guidelines that says we will only go after reporters under exigent circumstances, where there is need and where we have exhausted alternative sources. And in fact, they'll tell you that these requests for reporters' confidential sources are therefore very relatively rare. Chuck Rosenberg testified in 2005 before Congress that there had been only 12 press subpoenas in 15 years. And there's an arduous set of internal procedures you have to go through to get clearance. But in the last 2 years, by my count, there are 10 different news outlets that have been subpoenaed in the litigated cases I've just described. 4 subpoenas alone in a case I had a privilege to represent a newspaper in. Full disclosure, I helped to represent the Hearst newspapers and the reporters who broke the Balco steroids scandal, the story about the manufacturer near San Francisco that was allegedly supplying illegal steroid substances to many famous athletes. The most famous is Barry Bonds, but there were many others. There was a series of articles in the San Francisco Chronicle published about this grand jury proceeding investigating the underlying drug distribution. But the subpoenas arose in the Balco case after the indictments had come down, after the government had already produced Jenks material to the defendants. So there was discovery material that was going to the trial. And in fact, the case about the subpoena was litigated after the defendants in the underlying drug distribution scandal had pled and served their time. So this was not a case in which the government was subpoenaing information about leaks in order to investigate an ongoing crime or prevent an imminent crime. It was a case that was really retroactive. So, and there were 4 subpoenas in that case alone. Now, I give that as an illustration of what is perhaps a more promiscuous use of subpoenas on the government side, more promiscuous use of confidential sources on the press side, more promiscuous use of efforts to get at reporter sources on the government side. Even where there is diminished governmental necessity, the war on terror is one thing, but the war on steroids, different matter, perhaps a different degree of necessity, less exigent circumstances. And as I've suggested, this was a case in which this was retroactive. It was after the fact. And second, where you can question whether there was really exhaustion by the government. If you think about a leak case, the government has ample opportunity to do internal investigation to see if there's a government source who is the leaker without going after the reporters. And it also has the power to subpoena and seek testimony under oath of all the people within the coercive power of the grand jury process, including the defense lawyers, to see whether under oath they deny being the source. It turned out in the Balco case, and that's what mooted the appeal to the Ninth Circuit, that the defense lawyer had been the source of the leaked grand jury transcripts. He later was outed by a Confederate and is now pled and is getting a sentence higher than what was recommended. But this was a case in which he was never called in under oath. So the government had gone after the reporters before, I would argue, exhausting every alternative of internal investigation or subpoenas under oath of the possible sources in court. Third change, promiscuous use of sources by the press, more promiscuous use of subpoenas by the government. A third change is really in the interaction between the two. The dangerous liaison between the press and the reporters, a rise of leak culture in which there's a cozy relationship, the relationship that was on display during the Scooter Libby trial as reporter after reporter came to the stand and described daily life in Washington as being a series of conferences, breakfasts, lunch, and calls in which the danger is, as I think Justice Powell anticipated in Brandsburg, the press might become the pawn of government, that the press might become manipulated by government or subject to the selective distribution of information by government under the guise of a confidential source. That kind of dangerous liaison is a change too. I'll close by saying that those 3 changes may make things look different today, but as much changes, much is still the same. The context may have changed, but the first principle is no different. That the solicitude for the First Amendment should still guide our thinking, and I think if we asked what would Lewis Powell do, WWLPD, if we channeled him into this room right now, I believe that the need for a Powell-like balancing is more, not less important, given those 3 changes I've described, the change in the culture of the press, the change in the culture of the government, the change in the culture of the relationship between them, for several reasons. First, in a war on terror, in times of national security crisis, it is more important, not less important, for an enlightened citizenry to be able to know what's going on about the execution of that war by its government. I'll quote from Zechariah Chafee, a famous First Amendment defender on the Harvard Law faculty at the beginning of the century. He wrote an article in 1919, just as the government was passing amendments to the Espionage Act to try to contain anti-war efforts during World War I and the United States entry into the war. He said it is precisely in times of war that we need more, not less, secrecy from government so that the citizenry may decide whether the terrible costs of war are justified. So I would echo Dean Smolla's closing remarks in saying that the vital need for an informed citizenry and the protection of leaks to the extent they are needed, the protection of reporters' confidential source information to the extent that's necessary to getting information to an enlightened citizenry is more important to democracy than ever. Second, to the extent we're talking now about leaks, rather than, remember, Brandsburg arose in a prosecution of drugs, arson, firebombing. The case was about underlying crimes. And in a way, going after the speech, going after the reporter's news gathering was just ancillary to that clearly content-neutral effort at law enforcement. But a leak investigation goes after speech and nothing but speech. And we always worry more when the government is going after speech and nothing but speech, rather than just going after speech as a tool at getting at another end. It's a far cry from investigating or preventing crime independent of expression. So I think if we were to say, what would Lewis Powell do? I think that he might do something like what judges like Judge Tatel on the D.C. Circuit or Judge Sack in dissent in the Gonzales case in the Second Circuit suggested we ought to do. They said, in a leak investigation case, before you go after the reporter, we ought to ask, not only does the government really need it, and has it exhausted all alternatives? Has it done a sufficient internal investigation? Has it asked the court to ask everybody, including the defense lawyers under oath, whether they're behind the leaks? In a leak investigation, say Judges Tatel and Sack, in Tatel's concurrence in Judith Miller and Sack's dissent in Gonzales, they said, we ought to also balance in court the harm that the leak causes. That can be a terrible harm when you're outing the covert identity of a CIA agent against the value of that information. That information, the identity, may have no public use, and Judge Tatel, in applying the balance, said it was an easy case for him to say that the Judith Miller subpoena ought to be enforced, that the harm of the leak of Valerie Plame's identity outweighed any good to the public from that revelation. Or Judge Sack suggested a similar balance in Gonzales. And I tentatively suggest, subject to correction by Justice Powell's son and daughter, that he might have thought that that kind of balance was appropriate in a leak investigation. Now, I think Justice Powell also would have said, now let's be cautious. There are dangers in that kind of balancing, the good of a leak against its harm. One is, who's the press? Defining who the press is, and even deciding who gets to invoke the privilege, creates a danger of making government a licensor. It's been a big headache in the draft bills to pass a federal shield law to figure out how to define the press and how much of the blogosphere to include. Second, you might worry that balancing may sound good, but in the end always favor the government. Learned Hand many years ago in the Masses case during World War I and the Red Scare afterwards, he said, we should have bright line rules under the First Amendment. We shouldn't have balancing because it lets, he wrote in a letter, it lets Tom, Dick, and Harry DJ, Tom, Dick, and Harry district judge, decide according to his own predilections. And so he says, I don't like Holmesy's tests. Wouldn't you like to be able to call Justice Oliver Wendell Holmes Holmesy? That's why I don't like calling him. So you might say balancing may tend to just favor the government anyway. And finally, I think Justice Powell might have said, be cautious in balancing because to allow judges to weigh newsworthiness is to create the danger that their subjective preferences about what is and isn't newsworthy will intrude. I can tell you that there were Pulitzer Prizes for many of the stories that are behind the leak investigations underlying the Miller case, and there were many awards to the reporters who broke the Balco steroid story, and many who would say that that was a noble service because it got steroids out of not just professional sports, but out of college and high school sports where steroids could really cause lasting harm. But I think you might caution those that having judges weigh newsworthiness should be done with caution. But I think in the end, Justice Powell would still say, I think I was right the first time in Brandsburg versus Hayes, that the only way to deal with these changes in the background circumstances, the rise of the new access to information provided by the Internet, the government's felt necessity in a war on terror to press the press harder, and these new dangerous liaisons between press and government, the only way to address that is with solicitude for the First Amendment and with balancing. And I think he would say that even if it's right, that even if it's true that the government will win lots of these cases once they're litigated, it's very important to balance anyway because it forces the government to have to articulate its reasons for asking reporters for their information. And I think he might recall the phrase often invoked by his colleague Justice Thurgood Marshall on the court. Marshall used to say the value of the sword of Damocles was not that it falls, but that it hangs. that if you have to come to court and justify yourself under the First Amendment, you won't tend to be too rushed to violate it in the first place. So I venture to close by saying, what would Lewis Powell do? He would say, I was right the first time in Brandsburg versus Hayes. We need judicial balancing to have solicitude for the First Amendment, even while we protect the important values the nation seeks to honor in the war on terror. Thank you very much.
Thank you. I will be very brief. I have dealt with the press in 4 different government jobs. First time was as an assistant U.S. attorney in New York when Rudy Giuliani was the U.S. attorney. And I had been told that the most dangerous place in New York was actually not crossing Fifth Avenue by Rockefeller Center between the crosswalks, but it was between my boss, Mr. Giuliani, and a microphone. I was a brand new assistant U.S. attorney, and I was at a press conference with Mr. Giuliani, and I was standing behind him. And after he gave his prepared remarks, he stepped back slightly, and a reporter asked a question. And it was clearly a question he didn't know the answer to, and that I did, this 26-year-old assistant U.S. attorney. And I froze, because I remembered what I'd been told by my seniors about crossing that space. And there's a picture, actually, that I have of me standing there frozen, and Mr. Giuliani slightly off-center. And it wasn't until he turned and nodded to me that I stepped to the microphone, risking my life, and answered the question. I had almost no dealings with the press as an assistant U.S. attorney in New York. Then I got to Richmond as the managing assistant U.S. attorney, and I dealt with the press as we would announce our indictments and arrests and searches and seizures and results in significant cases. And it was then that I came to realize, more acutely than I had in New York, just how vital the press was to what we did for a living as federal prosecutors. We sold a product, which was general deterrence. And the only way for us to sell it, to deter would-be bad guys, was to get the press to tell the world about what we did. So I learned a lot about the value of the press. I also learned something about the responsibility of the press. There were a number of times in Richmond when reporters got wind of arrests that were imminent or searches that were imminent and came to me and asked me about it and told me about it in advance and agreed to hold stories when I explained what would happen, the dangers that would face a law enforcement officer going through a door if somebody knew they were coming. They were very, very responsible about protecting information when lives hung in the balance. Now, of course, they always wanted something in trade, and I don't mean pens and pads. They wanted a heads up on something that maybe was more appropriate for them to know. And we struck balances. We made those trades to accommodate their compelling need to publish and to tell the world, a need, frankly, that we often supported to try and get our word out, and our need and their need, because they are people who care about other people, to protect what matters most. Then I got to New York in the job Mr. Giuliani held. I was the United States Attorney in Manhattan, and among other things, indicted Martha Stewart, and learned that you needed 2 risers for the cameras when you indicted a major national security case, but you needed 3 when you indicted Martha Stewart. And there was much more interest in that important matter than in some of the other things we did. And I learned an awful lot about the role the press plays in getting the message out, the message of deterrence we tried to send in the summer of 2002, what I call the summer of corporate fraud. I also learned how important it was for the prosecutor's office to interact with the press, to give them information they want, public record information most often, but sometimes an off-the-record chat so they didn't go astray in reporting something about a pending case. Then I got to Washington, D.C., and I learned a whole lot of stuff that I never imagined when I was an assistant U.S. attorney with Rudy in New York, when I was the managing assistant in Richmond, or when I was the U.S. attorney in Manhattan. I learned, as Kathleen said, that there is, in fact, a symbiotic relationship between the elites, and I used to be an elite, thank God I'm no longer an elite, the elites in government in Washington and the elites in the media in Washington. I learned that everybody leaks when they are not decrying leaks. And that, of course, raises the question of what is a leak. Everybody uses anonymous quotes. I should stop for a second. Not everybody. Two branches of government leak like sieves, the executive branch and the legislative branch. The judiciary, I'm here to tell you, does not leak, and I'll get back to that at the end. I learned that leaks, so-called, can be a good thing. It can be important to be able to speak as a senior administration official about some initiative that's coming, to float it out there in a way that you'll be able to gauge a response. It can be important on the Hill to be able to do that. It can be very important to do what people would call leak. I also learned that the press is in every room at the highest levels of government in Washington. And what I mean by that is both literally and figuratively. Figuratively first. There is a saying in Washington, inside the government, that everything leaks eventually. One of my colleagues, a very senior official, once said to me, the only way two people can keep a secret in Washington is if one of them is dead. Okay. Now, why do I tell you that? That has a remarkable effect on decision-making at senior levels in Washington. Because seated in that room with the decision-makers is a figurative press. The press that will be the recipient of what the decision-makers believe is the ultimate leak of what's being discussed there. And that focuses the mind in very, very important ways. We used to talk inside meetings about the New York Times test or the Washington Post test. How will we feel when this is on the front page of the Washington Post or the New York Times? It often changed decisions or drove them in a slightly different direction because of the figurative presence of that fourth branch of government. Remarkably powerful. I also said they were there literally. When you go to see the president in the Oval Office, as I did many mornings to do the terrorism briefing with the director of the FBI, you stand in an anteroom. And in that anteroom is kind of a coffee table, maybe a little higher than a coffee table. And seated on that table every morning are major newspapers from around the country, and then a thick printout of the clips, summaries of news stories that touch all parts of the federal government, organized by branch of the government. At the Department of Justice, every morning I would get emailed a version of that focused on the Department of Justice's issues, and then there'd be a hard copy on my desk every morning. It is one of the very first things that the seniors, the elites in the federal government read every morning. I would get a terrorist threat briefing, and I would look at the clips to see what the media was saying about the work we were doing and what had ended up in the media that maybe we didn't want there. Extremely powerful figurative presence and literal presence. Official Washington has an obsession with what goes on in the media for a whole lot of good reasons, ones that I think you can imagine. They care the way the world is understanding what the government is doing. Prosecutors care about the messages of deterrence getting out. People care about what's said about them personally. But the headline is, the headlines matter tremendously and shape everything that goes on inside of Washington. And I'll get back to explaining why that matters so much in about 30 seconds. Some secrets must be kept. The first thing that surprised me is that not everything leaks. That remarkable story about what happened that night in the hospital, that didn't leak. Because I didn't leak it, and Chuck didn't leak it, and the people who were with me that night did not talk to the press about that. It was 3 years later that story got out when I was under oath and asked about it. Okay? Not everything leaks. But some things do leak and hurt important efforts, like law enforcement efforts and national security, counterterrorism efforts in particular. All of us would agree that some secrets must be kept, have to be kept. You can imagine your own. Troop movements, search warrants about to be executed, the undercover identity of a covert operative with the CIA. Some things can't leak. The flip side of that is, when they do leak, the government has to do something about it. Has to, because we care about the rule of law. We care about some secrets not being disclosed. And you can imagine the kind of world we live in if we never pursued a leak when it mattered most. So we have to investigate the leaking of some secrets. So how do we do that? I agree with my colleagues that a balancing test is the most appropriate. But I believe that balancing is actually best done the way it's been done, as you heard, for the last 34 years under the Department of Justice's guidelines. I believe that journalists should be careful about what they ask for when they talk about wanting statutory balancing enshrined in law so that federal judges do balancing around the country. I frankly think journalists would be worse off. Remember I said I'd get back to the influence of the media? I have sat there and reviewed requests from federal prosecutors to subpoena media organizations for their phone records or for their bodies to come in the grand jury so they can be asked about confidential sources. In every one of those meetings, it's required by the regulations, is the head of public affairs for the Justice Department. He is there as the voice of the media, or she, and what he or she is saying at every one of those meetings is, if we do this, we're going to get killed. The press is going to be furious. They're going to nail us in every story for the next 10 years if we do this. And we care about that. They're in that room. The press has power. I hate to be on camera telling them this, but the press has power that maybe they don't even imagine from the outside, inside the government. Now, why does that matter? Because when I'm doing the balancing, with the voice of public affairs there and the voice of a whole lot of different institutional interests that have been there for years and years, I'm being very, very conservative, as I think have all of my predecessors as Deputy Attorney General and all Attorneys General. I turned down a whole bunch of requests for the reasons that, for most of the reasons that I laid out. Our fear of the reaction we create in the press, our fear of being too aggressive, our fear of our inability to foresee the unforeseeable. I think if you shift that process outside the Department of Justice to the one branch that doesn't leak, remember I told you that? The judicial branch does not care how the media views them in the way that the executive branch does, the legislative branch does. I guarantee you've never walked into a judge's chambers and seen news television on all the time, or clips on the table. They are not worrying about it the way we were worrying about it. I think you'd also see the Department of Justice feeling a little freer to ask for permission because they wouldn't take the hit if the reporter was subpoenaed. Who would take the hit? The judge would take the hit. I think reporters ought to be careful how hard they press for a change from that which has worked so well for the last 34 years. I think a balance is appropriate, and I think especially in these national security cases and law enforcement cases, it is best struck inside the United States Department of Justice. Thanks for your time.
Got a few minutes for some questions. Mr. Bowen.
This is for Kathleen Sullivan. Given the nature of the cases where oftentimes it's just one source in the government telling the reporter whatever the information is, in cases where the government's interest would win on balance, how liberally should we construe the exhaustion requirement that you're talking about and that Judge Tate talked about?
I think the government should still have to show to the judge that it really exhausted. I think exhaustion is a real issue, and relevance is a real issue. Cumulativeness in some of these investigations, how many reporters do you have to subpoena before you go after things? So I actually think having to demonstrate those things before a judge in camera if necessary. I mean, let's not forget that lots of the lower court cases have said the judge can review the government's showing of exhaustion and relevance privately rather than publicly. I think that having to go before the judge, and even I think Mr. Comey's described beautifully what the effect of a balancing test is. It forces self-regulation because you want to come up with the evidence that you could justify the request if you're forced to before the judge, even if you never have to get there. So I think if it ever does get to the judge, it ought to be a stringent requirement.
Also for Dean Sullivan, if you assess privilege on a case-by-case basis, doesn't that mean that the sources are essentially gambling on the newsworthiness or the importance of the information they're leaking? It just seems to me that if it's going to be assessed later, being subpoenaed after the fact and losing is not going to be very reassuring to me as a source.
Yes, the question is, are sources gambling if the privilege is assessed on a case-by-case basis? And I think the answer is yes, they are. And sometimes the press betrays them. There's a wonderful case called Cohen versus Cowles Media in which the press revealed the identity of its source. A staffer in candidate A's campaign leaks that candidate B had been arrested for a shoplifting offense years ago. The press says, well, it's relevant to disclose that the source is candidate A's staffer. Candidate A's staffer didn't last on that staff after this was revealed, and he sued for violation of contract. You breached your contract to me. So sources are always gambling. And Justice White, the author of the Brandsburg Plurality Opinion, said, tough luck, newspaper. If you breached your contract, you ought to pay. You can't, on the one hand, come in and say, oh, we need to keep the confidentiality of our sources, but we don't have to pay when we breach it. So first point is that sources are always gambling on the press to begin with. But second, I think it's not a bad idea to have sources a little uncertain about how guaranteed the confidentiality is, because that helps to push us back into self-restraint on the press's side, so that the press isn't overusing sources when it ought to use old-fashioned shoe leather instead of the anonymous source.
Yeah.
Mr. Comey, do you feel like the global war on terror changed the balancing act in the Department of Justice, both in terms of national security cases going more aggressively after the press, but also not accommodating freedom of information requests and more secrecy versus open government?
The question was, do I think that the global war on terrorism changed some of the habits and balancing inside the Department of Justice? I don't think so with respect to the press. I mean, I'm sure Chuck Rosenberg will answer. It sounds like it all went to heck after I left. But I don't think so. I mean, you've seen some high-profile stories that have implicated some of these issues, driven by the fact that there were a variety of counterterrorism programs that became controversial and were disclosed to the media. The secrecy question is probably beyond my ken, although I have the same reaction a lot of journalists do. I would see stuff inside the government that was stamped secret, and for the life of me, I couldn't figure out why it was. I think that's just, frankly, I don't think that's part of an evil plot. I think that's just the easiest thing to do for a whole lot of people. It takes a lot more time to figure out what is and isn't secret. You just stamp everything with this thing you got on your desk. You can move on to the next item, and that is not a good thing. I mean, but that's a whole other symposium.
Just a quick addendum. Jim, I was struck by your claim that the judiciary doesn't leak. And it's true, I suppose, for the most part. But there is a kind of transgenerational leak process in that justices, some of them at least, later leave us their papers. And remarkable journalists like Linda Greenhouse write books about Justice Blackmun or Joan Biskupic about Justice O'Connor. And I feel almost as if I'm in the possession of a leak. Because this is from the secret chamber. This is the scorecard in Brandsburg versus Hayes in Justice Powell's handwriting. And you see the deep ambivalence because, as Kathleen has said, there was this solicitude for the First Amendment. A nice euphemistic word, solicitude, right, that he uses. But it's fascinating to actually look at the handwriting. He's got Douglas, reverse. Marshall, reverse. Reverse is for the press, all right? Brennan, reverse. Stewart, reverse. Uh-oh, here come the late returns from downstate Florida. White, affirm. Blackmun, affirm. Rehnquist, affirm. Chief, affirm. It's 4-4. And here's Justice Powell in his own handwriting. Affirm, as I do not think there is a constitutional privilege. How interesting. That's why I think there may have been a balance, and he may have wanted us to get it back the way he originally intended, but I'm not sure even he, at this moment, was quite sure what he intended.
Well, just to follow up on that, there's only one express constitutional privilege, and that's the Fifth Amendment privilege against compelled self-incrimination in a criminal case. And so, in a sense, he might say there's no First Amendment privilege that you can derive simply from the text, but I don't think there's any question that he was trying to infuse First Amendment thinking into the balancing process that would otherwise come up in a grand jury subpoena evaluation under Criminal Rule of Procedure 17 or so forth. So you're right. Solicitude is not the same thing as a right, but I don't think it's chopped liver either.
I agree, and actually, if you think about the connections between both of you on this, it's this interesting tension between the informal arrangements and self-restraint and institutional traditions and respect for the values of the First Amendment, and making it a formal rule of law, which maybe some of us would prefer, but he was clearly on that edge between those two.
So I guess I think that his sense of solicitude would increase and veer closer to a privilege or a right the more he thinks that self-restraint is breaking down. And then just to follow up on the last question, I do think there's been a rise in the culture of government secrecy, sometimes in places where we later wonder, why did that have to be secret? And it's come up in lots of matters, from the Energy Advisory Committee run by the Vice President to the discussion of the warrantless surveillance program by the National Security Agency. And when these things, if the government's going to increase the culture of secrecy, then leaks become as disreputable and undesirable as they might be as a general practice, sometimes the only window into government practices. So I think to the extent that solicitude is a kind of sliding scale, it would be responsive to the secrecy and breakdown of self-restraint on the other side. So I'm just speculating that he wouldn't necessarily say it was a First Amendment privilege, but his solicitude might have increased.
Well, it's 10:30, so we break now for 15 minutes, come back at 10:45 for the second panel. Thank you very much.